Here we go.
Here we go. Here we go.
You guys ready?
Let's go. Yes, sir.
So back down.
Come to order, please.
Anyway, we'll probably talk hours.
Come to order, please. Today's meeting of the Municipal Code Enforcement Board is called to order on Wednesday, May 22nd, 2024. Welcome, everyone. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to council chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceeds will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to please rise and be sworn in by our clerk.
Do you swear or affirm to tell the truth throughout your entire testimony? I do. Thank you.
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
Motion to approve.
Second.
All in favor?
Aye.
All opposed? Minutes are approved. Is there anyone here to speak on items that are not on today's agenda? No? All right, we will get to our new business then. First case on the docket is 4.1 on our agenda, continued from February 28th, 2024. Case 32-22, status update regarding respondent Coachman Creek Condo Association at 2625 State Road 590, Building 5, in violation of code for unsafe building.
I'm sorry, I have Jason Cantrell's name on it. I just noticed that. This is John Narden.
Oh.
Sorry.
Inspector Narden, come to the podium.
Good afternoon, Board. How you doing?
Good afternoon.
As for the item here, the folks, all they needed to take care of out there, we had the fire final for the complex, for the building final, a building final, and electric final. The fire final has been completed and inspected and passed. The building final and the electric final will be inspected tomorrow. Electric final, from what I've looked at, seems like it'll pass out there. Building final should be fine. They just need to get into the units to access everything. They had previously set up an inspection for the building final, but couldn't get into all of the units. So the inspector noted that we need to be able to get into all of the units on the same day that we're in there and get things done. So it seems like it's actually getting wrapped up and taken care of.
Okay, good. Board, do you have any questions?
You want a continuance?
We want to have them back next month to give us another status update?
Yes.
Okay.
See that it's
Someone
closed
want to
out.
make a motion for that?
I make a motion that we continue this till
The
June
next meeting is June 26th.
June 26th for an update.
Second.
All in favor?
Aye.
All opposed? Motion passes. Thank you, sir. All right, our next item is 4.2 on our agenda, continued from April 24th, 2024, case 51-24. Find respondents ProStar Multi-Services LLC at 19080 U.S. Highway 19 North in violation of code for prohibited signage, and issue an order with a compliance deadline and fine if compliance is not met. Ma'am, are you here to speak on the property, ma'am?
I am the owner of the business.
Okay, if you'll just have a seat, we'll get back with you in just a second, okay? Thank you.
Right. Good afternoon, Board. Stephen Burkert, sign inspector for the City of Clearwater. This is case 51-24 at 19080 US Highway 19 North. It's a repeat violation. All right. There's one violation regarding code section 3-1804E for electronic changeable message signs. The property was posted with an affidavit of posting and the notice of repeat violation on February 22nd, 2024. This is just an definition of the violation. So a repeat violation means a violation of a provision of a code by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated, or who has admitted violating the same provision within 5 years prior to the violation, notwithstanding the violations occur at different locations. And that's the definition of section 3-1804E. The following types of signs are prohibited: electronic changeable message signs unless otherwise allowed herein, or those that are existing, legally non-conforming message signs. Legally non-conforming message signs shall only be those that have general messages that change no more frequently than once every 1 hour and meet the requirements of this Division 18, or they are signs that only display a change in time and or temperature no more frequently than once every minute, as necessary to correctly reflect accurate information and not be misleading. So on November 29 of 23, the case 5124 was brought before the Municipal Code Enforcement Board and was found in violation for violating Code Section 3-1804E. The board ordered that no fine be imposed since the violation was corrected prior to the hearing. If the respondent repeats the violation within 5 years, the board may order the respondent to pay a fine up to $500 for each day the repeat violation continues to exist. So this is a video of one occurrence I had on February 22nd of this year. It shows that those signs are running. And then, next page, this is from February 21st, 24, the same situation. So I had 2 days where the signs were running. Again, compliance original could be met by removing the signs from the property or turning them to solid light, continuous light.
So the changing of that sign,
The changing of
Is
the
what?
sign, so our provisions for signs say basically signs cannot change, blink, flutter, flash, and that specific type of sign we call them, again, electronic changing message signs that show a running message, basically like displaying some kind of message that's running, that's not allowed. This was from May 20 of this year during the day, so the signs are now set to solid light, which is in compliance with our code.
Is or isn't?
It is in
Okay.
compliance. Okay, compliance for the electronic changeable message signs has been met. Recommendations for the case 51-24. The violation of electronic changeable message signs, requesting a fine of $500 per day for the following dates: February 21st of this year and February 22nd, 24, which is a total amount of $1,000. Presentation.
all right, board, do you have any questions for Inspector Burgart?
Okay.
All right, Inspector, if you'll have a seat.
I do.
Oh, wait.
Just, I want to make sure I understand. So there was a previous violation, then it was in compliance, and then for these 2 days it was observed to be out of compliance, correct?
Yeah, there was a declaration of violation
Yeah.
at Code Board, and that the two occurrence happened after the declaration of violation.
Thank you.
Hi, will you come forward now, please? Will you state your name and address for the record and your relationship to the property.
Okay, my name is Remziya Salik,
Could you spell that for me?
Remziye, and last name is Salik, Celik, and the address of the business 19080 US Highway 19 North, Clearwater, 33764, and I'm the owner of the business.
So what's going on here with your sign?
Yes, so actually that was a new business and we tried to do some lighting around the building and inside also. So we kind of get the couple electrician in there and then we ordered those that was showing all those flashy lights.
Yeah.
And then they put it on. I personally did not know that those flashy lights was not in the code system that I'm not supposed to. So once we got the letter and then I tried to fix it, I made an appointment with a couple people and then they came, they said they fixed it. They did some sensory, they said they're not gonna be there. So then a couple days later we found out that it's still flashy. So what I did, I put all down those systems. I got a new stable one. I corrected all the electric. There is no flash, no nothing is going on. After like on the February 23rd, that since then we completely put down all those flash, all those the one that going on and everything else just stable. I only have a regular stable light right now.
It's all fixed and
I
solid
will
now.
fix everything. I spent a lot the second time, but I corrected.
When you were
I'm sorry.
out of compliance for those 2 days, couldn't you just unplugged it?
Actually, I didn't know that. What should I do if I unplug it? I was new to this
When in
business.
doubt, unplug.
Because it was connected with, I had some videos, the speaker system, and everything else. I was afraid to touch it, that if I put all systems down until the electrician comes. So I made an appointment, and then we ordered the electric, and everything else went through. Because
But you could have called your inspector too.
I didn't,
You didn't think of it?
I did not know like what, if I can contact to them about what to do. They might get upset or something. They will say, why you don't know? It's your electric, you should know. So I was was not comfortable to call the inspector.
But you went through it before, you should have known that.
I did not know. I was not aware of it, but once that I got those errors, that I
Okay.
said I am going to completely fix it. That's all I can do.
I have a
So completely fixed, and then everything is down, no flash, no light, no, nothing is going down right now.
so do these signs, I have a
The
question.
signs, yeah.
These signs, these hang in the window? How do they power up? Do they power up with a plug-in cord?
Is it plug? But what's in the beginning? This plug, those electric, it was connected to we had a TV inside. It was kind of complicated. I was not comfortable to put all systems down. Like my camera was going on, it was gonna going off, the speaker system was going on, everything else was kind of connected. I was not comfortable to take it out, put everything, all my system down, that I was gonna be completely down, and
Okay, Thank you.
that was my fear.
understood.
All right, board. First violation. What do you guys think?
Well, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second.
All in favor?
Aye.
All opposed?
You have to look at, this is a repeat violation.
Oh, sorry.
That's right.
Page
I haven't
3.
slammed together.
Thank you,
one.
Mr.
I move to find the respondent was in violation of the code referred to in the case and has committed a repeat violation.
Second.
All in favor?
Aye.
All opposed? All right, motion passes. All right.
Second.
What do you want to do about the second motion?
You may read it?
If,
Okay. Oh, go ahead, Bob.
Go ahead.
Okay. I move to enter order that a fine of $500 per day be imposed for the days the repeat violation existed for a total of $1,000, payable within 30 days. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation again, the board may order a fine up to $500 for each day the violation continues to exist.
Second.
All in favor?
Is that okay with the city? Okay,
That was the recommendation.
okay.
All in favor?
Aye.
All opposed? Motion passes. Thank you, ma'am.
Thank you very much, thank you.
Our next case is 4.3 on our agenda, continued from April 24th, 2024. I'm sorry, this one is continued to June 6th. I missed that one.
Okay.
My
Is it?
bad. Board,
4.3?
sorry.
4.3.
Okay.
4.3 is
Yeah,
continued.
4.3. I didn't see it.
Sorry.
So now we're moved on to
Oh.
4.4 on our agenda, case number 56-24. Fine respondents Clearwater RES Trust, Ficken James R. Trey at 1608 North Osceola Avenue in violation of code for exterior surfaces, roof maintenance, landscape, abandoned building, and inoperative vehicle, and issue an order with the compliance deadline if the fine if compliance is not met. Inspector Casman, you have the floor.
All right. Good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is for 1608 North Osceola Avenue, case number 56-24. Hold on.
It takes its time.
Slow.
Let me try something just real quick.
The mics just ain't caught up yet with the wheel.
But it might, if it would please the Board, is it still easy enough to read like this?
Yeah.
Yes.
Okay.
Yeah.
We're just going to go ahead like this.
Yeah.
There's 5 violations of this property. One is Code Section 3-1502B for exterior surfaces, Code Section 3-1502D1, D3, and D4 for roof maintenance, clean roof, paint and roof, Code Section 3-1502H1 through 5 for landscape maintenance, Code Section 3-1503B6 for an operative vehicle, and Code Section 3-1503A, B1, B2, B3, and B9 for abandoned building. Definition of abandoned building. Is abandoned building means a building or structure that is deserted by the owner and left unsecured or is not maintained. Evidence of desertion and lack of maintenance shall include but not be limited to unaddressed code violations, lack of required building permits or certificate of occupancy, lack of business tax receipt, or lack of active utilities. This is the date notice of violation was sent out with compliance state. Did get certified mail back and have been in contact with the owner via email on and off for the past few months. Maybe I'll try making this a little bit bigger and see if we have better luck at this point. 1608 North Osceola Avenue. This is just the front look. A little bit of issues, like kind of dead plants in the front. There's a little bit of issues with the exterior. The roof could use a cleaning, and there's a bit of rustiness all around the gutters. This could just use some love and care. On the side here, if you look upward towards the top of that left section of the roof, there's some shingles missing up there. Not shingles, I'm sorry. There's just some siding missing. You can see the cactus is in great shape, and some of the plants aren't in great shape either. The roof could use a cleaning again. At the one corner up front, there's also some missing fashion soffit, though that was repaired later. In the back of the property, now this is kind of a weird street on Osceola, there's actually an alleyway that goes in the rear of a bunch of properties back there that can be walked down. This was in the back of the property. Some issues with the garage back there, some exterior issues. There was a car parked in the driveway, but there was also this trailer, doesn't have a license plate on it. If you look a closer look at the garage above the gutters, again, just the same thing, dirtiness on the side. The snake plants are kind of taking over the whole backyard on both sides of the garage. And on the back of the home, again, another missing section of the exterior. And this is to show the utilities have been off the property since 2019. So this was after compliance date, up front again. Not much has really changed. Same issue over there on the exterior, and again, just the building needs a cleaning, needs to be repainted, whatever's fading or peeling paint. The garage in the back still in the same shape. That's where showing the kind of snake plants just taking over the property on the side there. And then again, the issues with the side of the garage, and the same issue with the rear of the home. And then today, this morning, like I said, not a ton has changed. It still needs a good cleaning. It's like we're chugging again. And then, see, there's some piles of debris that have been put out front. I've spoken with the owner. He has been working on it a little bit, but without active utilities, the solid waste is not going to show up to take away anything. This was just 2 days prior. I noticed that vehicle in the back had been turned around. and the tag on it's been expired for a few years now. And the hauling trailer was still there. Garage is still in the same shape. If you look at the bottom right corner, near that little potted plant, you see there's some additional damage to the exterior of the garage. And then again with the roof on the garage, just nothing's really changed. And I got one more photo of the exterior, I believe, but we're chugging just a little bit.
Is that a board in the window down there?
I think it's just the board that you can see from the inside of the building.
okay.
I don't think the window's boarded up.
Okay.
And then again on the exterior of the building. And the utilities are still off the location. So compliance met for the exterior surface by remove all plant materials from the structures, repair of structural damage, repainting whether it's chipped and fading / peeling paint or mildew and algae. Compliance met for the roof maintenance by repairing all fascia and soffits, finishing fascia and soffits with paint or covering, cleaning / repair / repainting of roof tiles. Compliance met for landscape maintenance by removing all dead plant life from the property, maintenance of all existing plants to present a neat and attractive appearance, and removal of debris from the premises. Compliance met for inoperative vehicles by ensuring all vehicles in the premises display a license plate with current tag or are removed from the property. And compliance met for the abandoned building by compliance with all existing code violations and restoring the utilities or demolishing the structure. So, for this particular case, 56-24, requesting compliance on or before June 22nd, 2024, or a fine of $150 per day per violation for each day the violations continue to exist.
Board, do you have any questions for
I do.
Daniel?
How many violations are there total? Because I'm looking at 150 per day. How many?
5. Exterior, roof, landscape maintenance, it's abandoned, and there's inoperative vehicles on the premises.
So when fines are assessed, if those all are in existence, that's $750 a day.
It's
Okay.
true.
All right.
Take action.
Any other questions, board?
Is there anybody here to speak on it?
Is there anyone here to speak on this property? Sir, you come forward. State your name and address for the record, please.
James R. Pickens, 1608 North Osceola. Clearwater trustee, Clearwater Residential Trust.
Hello, Mr. Ficken. What's going on with this property?
Well, it's essentially been mostly vacant since 2014. When my mom started dying, I spent most of almost all of 2014, 15, and 16 taking care of her, and then lots of trips up to her place. And so it really has not gotten much attention. We did get a lot of the exterior painting done, I think 5 years ago. A guy charged an extreme amount for that. And then when I got the notice here and started work on it, I've been working on it pretty hard for the past 3 months. I've had to miss some time the last month because my only source of income is management from another property. And the tenant left a complete mess and full of furniture and destroyed the flooring. And so I've been having to spend some time with there. But now that we're getting close to this deadline, I've been hitting it pretty good for the last week or two. And a number of the issues you mentioned have been cured. So I don't know how to work the list. If you want to go through the list of the things that are cured, and I have, if I can make the picture work on this phone, I can show one or two of the items. But really, what I'd like to ask for is a continuance to. I've gotten a lot done in 3 months, and I can get a lot more done if you can give me another 3 months to get it wrapped up. We can go over the individual items if you like, and, several of those pictures, don't reflect the condition as of today, because I've been hitting it pretty hard, including.
Some of his pictures were from today.
Yes, but they weren't from the last, I've been working on it. I came here to the meeting, I thought it started at noon. So I've been back hitting it another hour and a half. And actually, some of them were not from today. They were maybe from a couple days ago. So number one, the car, I got it running, and it's out of there. I've got cleaned all the exterior surfaces of the building with, the chemicals. I've trimmed out lots of the snake plants. I got about 2 dozen of them and took them to a friend of mine. He's established his garden. And then almost all the areas of the plants where they overgrew the flower beds, I've gotten all those trimmed back. I've gotten probably another 7 or 8 trees just today, of those little small trees moving. So I'm reclaiming the backyard. I'm reclaiming the areas where the trees are overhanging the roof and touching the roof. I've gotten all the dead plants out of there, and I've replanted the front garden areas with some of the plants that were overgrowing the border, you know, from the backyard and the side yard. And so, you know, those are growing. Earlier today, all the soffits and fascias that had rotted areas, those were all
Mr. Pickett,
repaired.
excuse me for interrupting, but are you working on this place every day?
Yes,
So you are trying to resolve all these problems by yourself?
yes. And I had to have helper for doing the repairs to the soffits and the fascia
Okay,
boards.
I'm sorry.
He has
That's the answer to my question, thank you.
he has scaffolding, and to get up there to where he has, and I've been trying to get him to come out here to do that painting of the gutters, but haven't been able to get him to get here yet, and so I guess I'm gonna have to find somebody else with some.
James, excuse me, how long has your property been abandoned?
Well, I don't know what you mean by abandoned, vacant.
No one, yeah,
With-
no one living there, no utilities, things like that.
Utilities, the electricity has been on continuously for 30 years.
My question is, why have you waited so long to start these repairs?
Because I've had other properties that I needed to get prepared to get income to get this one repaired. And so I haven't been staying there for several years. Another property that I'm trying to get repaired has less problems on the interior that this one has. So I'm trying to focus on getting all these exterior things done and get that other property fixed up so I can get some rental income
But
from that.
meanwhile, you're accruing, you can accrue fines on this one,
I
and
don't-
maybe you took on too much.
Well,
I have a question.
Yes.
Have you spoken with your inspector, Mr. Casman?
just spoke with him a few minutes ago, just met him today.
Okay.
And I've got some feedback from him as to issues that are more important and less important, so I've got some focus
Okay.
of what to do. And one of the things,
Why didn't you speak to him
Let
earlier?
him finish answering my question.
well, we had emails back and forth,
Okay.
Okay.
you know, when this first started.
Okay. I've got a question to Mr. Casman.
It sounds like you're have done quite a bit and are still doing quite a bit.
Yeah, I'd be glad to show you some pictures that were just taken an hour ago, half an hour ago.
We can't do it on
Do you
here,
think
so-
that,
It doesn't work we tried it with her earlier, and it doesn't work very well.
Yeah.
you think that you can become in compliance by June 22nd?
Probably not. 3 months would really give me a little bit of room to work with it.
Well, I'm inclined to give you 45 days.
Can I ask a
No.
question to Mr.
Yeah,
Casman
you can in
first,
a
please?
second,
Thank you.
yeah.
Yeah, let me ask a question.
All right, Mr. Cat, if you'll step to the side, bring Mr. Casman back up for a second, sir.
Hey, how you feeling?
Good. I'm trying to reconcile a little bit in my own mind about some of the stuff that you've shown us and some of the efforts that, I'm sorry, Mr. Ficken has made. My apologies, I'm terrible with names. In your visits out there, have you seen some efforts toward compliance, and what are your thoughts?
The one little corner of the building got fixed, and some landscaping's been done, but trying to rush all this in 2 hours before code board, I was just out there at 10 a.m. You saw my photos. It was from literally today.
Yeah.
And I've explained to Jim, rather than trying to rush it, you know, let's take have a better game plan in taking care of the place. We've been in contact since about February. I get an email. The last time we spoke was March 8th. I laid out exactly what had to happen at the property. Explained if you show progress, I can give you additional time, but if there's no progress, you're just going to go to code board.
Okay.
So,
The other thing that I'm trying to reconcile is between what you've given us as a list of things that need to be correction and the fact that you guys have only first really met today. I know you've been emailing. I hear from Mr. Ficken that he's making some attempts to work on the property, but I think that if the violations are going to be cleared, it would seem that a communication between you two in terms of specifically what he needs to do might be valuable.
well, the recommendation slide pretty much had everything that needs to happen
Right.
with the property if you want to go back over it. I mean, if you want to look at some of the photos too, it's the issue with fading, chipping, peeling paint. There's obviously some missing siding. There's rust over any metal aperture on the home. The roof has to be cleaned. I don't know if there's any damage to any of those tiles, or they just need cleaning and then repainting. We have specific rules when it comes to roofs, about tile roofs in particular. The landscaping, like I said, he's getting there, but without any active utilities or trash, he's got to haul everything away as himself. Solid waste is never to come get anything.
Okay.
And again, with the vehicles, I've spoken with before about the hauling trailer. It's got to have a license plate and license, a current tag, and either that or just remove it from the property.
But he just said he has the utilities.
Can I speak to that? What is it,
Step to the
with the car, I got it running and out of there.
Permanently?
Pardon?
Permanently?
Yes,
Okay.
it's out of the city of Clearwater, never to be
Okay.
seen in Clearwater again.
Okay.
Unless it's just
That's
passing
good.
through on the way to the beach.
Okay.
And the trailer, that turned out to be more of a project than I thought. I put air in the tires, and one of them was flat, and so I had to dig and dig to expose it. And the first time I tried to get the lug nuts off, it wouldn't come, so I came back the next day with some penetrant stuff and couldn't get it done. And finally had to come back with different penetrant and borrow tools from my friend, what do you call it, a pry bar or
Right.
something. We finally got the lug nuts off.
So-
We dug and got it out, and then I took it to check why it leaked, and finally got it, had to take the tire off and sand the thing and put the tire back on, put the air, and then I had to dig it more.
All right,
to
so
get
let
it
me
mounted,
ask
but
you
I have-
this.
I have it mounted now.
What's the plan with the trailer? Is it staying, you're going to license it, it's going to go? What are you
I'm
going
gonna
to do?
get it out of there.
Okay, and what about the utilities? What's the plan with that?
I've got electricity. I've always had electricity, and to me, I don't really need water because it's vacant now. Once I get to where I can move back in, of course, I don't mind having, I need the water to be turned on, but, I just have the power on there just to have, power for the power tools for, for folks to try and help me. As far as all the soffits and fascias repaired that one area on the corner that you showed in this picture on the northeast corner of the property. We got that one repaired. We got 2 spots on the back wall with soffits and fascia, and 3 spots on the back side of the garage.
Okay,
And
so-
those have all been,
Gotcha. So
repaired.
skipping over the detail, you've done some, but you still have a fair amount to do, correct?
Yes.
Okay, all right.
And I'm gonna have to dispute the roof cleaning. That's a rare roof, and it looks the same as it looked, when I got the place 30 years ago. It's just a natural, patina that it's concrete tiles, and they're very rare to get. I found a guy that had used ones, and he wanted like $25 a piece just for one tile. And so, I really don't think it's gonna be beneficial for any attempt at cleaning. It's a uniform surface now, and it looks the way it always looks. And for that
Understood.
kind of roof, if I find another building with that kind of tiles on it, it'll look just the same.
Okay, so that's not for us to address here. I would suggest that you have that discussion with your inspector.
Okay, well,
Okay, 'cause he's
all right,
gonna be
we
your-
can talk some more about that.
Okay,
But, and it's like I say, I've gotten all the surfaces of the garage, the walls cleaned. All that streaking that accumulates over a few years, I did that yesterday.
got that.
And so that's all 4 walls of the house and 3 walls of the garage. And earlier today, I cut down a tree that was blocking passage to the southern wall of the garage.
I
and
got that.
So,
I understand you're working on the property, and that's a good faith effort on your part, okay?
I just wanted to point out that some of the things that he showed pictures of have been mitigated, even though the pictures were taken 2 days ago or whatever.
I get that.
I've made a lot of progress this week.
Understood.
Board, do you have any recommendations?
No, I have a comment, though. As far as standard of repairs is, our reference point is the code in terms of judgment calls on repairs. And I think those are, just as a comment, I think those are best addressed between the property owner and the inspector in terms of what that standard is. It's not for us to because those are set in stone. Okay, so it's not our job to evaluate those.
Well, I'm inclined to recommend giving him 45 days, moving it up 2 weeks from the June 22nd
Okay.
deadline. You know, you're gonna have to like get this moving along.
Good.
You know,
All
we're
right.
gonna give you 45 days.
It doesn't have to be completed in 45 days, but you got to show a whole lot of
You get with Dan.
enthusiasm as a code enforcement officer.
with
Well,
Inspector.
like I say, it's, you know, I think just the difference, from 2 or 3 days ago is significant. And I'll keep at it.
Keep in touch with Inspector Caspin, and, you know, you can get this all taken care of. All right, board, can I get a first motion?
Wait just a minute. Mr. Schultz, when you say it doesn't have to be completed, it does. That's what compliance is.
No, does have to be completed. However, until there's an affidavit of noncompliance, he can still work with the inspector. The
Okay.
inspector's going to work with him unless he finds that he needs to go ahead and do the affidavit of noncompliance.
Right. But the,
So you're both right.
Do we have a first motion yet?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second?
All in favor?
Aye.
All opposed? Motion passes. Second motion?
Do we have a date for this, 45 days?
Well, that will be,
45 days, whatever that is.
so 15 days out from June 22nd. So that
Say
would be-
say that again, please.
Hold on 1 second, sir. That would be
July, right around.
clerk,
the-
or
Right around
clerk
the 10th.
Nicole. What would that be,
10th of
June?
July?
Or July 10th?
June 29th?
No, 15 days.
July 10th.
15 days from the 22nd?
From the
Let's say to July 10th,
22nd.
just to be,
It's the 11th, July 11th.
July
11th, okay. That's on the,
So until
you
July
want to
11th.
take it? You want to take it?
no, go ahead.
I
So-
move
so-
to,
So when is your next meeting?
well,
45 days.
Hold on a
Yeah.
second.
That's when your next meeting
No.
is?
No.
Okay.
every month we meet, but I move to enter an order requiring the respondent to correct the violations on or before July 11th, 2024. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid, 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
All in favor?
I
All
second.
opposed?
Second. Second.
Oh, second,
Yeah.
sorry. All in favor?
Aye.
All opposed? Motion
Stay in
passes.
touch with your
Yeah.
inspector,
Yes.
okay? That's all I'm gonna tell you about that. Stay in touch with, on your progress,
Right.
okay?
Well,
Don't
you know,
forget.
he gave me the list, and I was working on all the things I knew on
You've
the
already
list.
told us that. Stay in
Thank
touch.
you.
We've already voted on it. Stay in touch
Thank
very
you.
closely with him.
Thank you for your
Mr.
time.
Fricken.
Yeah.
I'm sorry, Steve?
Thank you for your time.
Thank
Oh,
you.
thank you.
You're welcome.
Next case on the agenda is 4.5, case number 57-24. Find respondents George and Rasha Solomon at 313 Leeward Island in violation of code for short-term rental and residential rental business tax receipt, and issue an order of compliance deadline and fine if compliance is not met.
Good
You have the
afternoon,
floor.
Board. We're seeking a declaration of violation for this case.
Oh, all right.
These cases always are.
Anybody, someone's here to speak? Is there anyone here to speak on this case? No? Ms. Green, if you'll, just 1 second, oh, you want to go ahead? Do you want to go ahead with your presentation? Yeah, go ahead with your presentation. We'll bring you up in just 1 second. Thank you.
Good afternoon, Board. Sarah Green, Code Compliance Supervisor for the City of Clearwater. This is case 57-24 for 313 Leeward Island. There are 2 violations in this case. Code Section 1-104B is a development code violation for zoning, and Code Section 3-919, which is prima facie evidence of an illegal short-term rental. And the second violation is in Code Section 3-2302 for residential rental without a business tax receipt. Notice violation was sent on February 29th, 2024, with a compliance date of March 22nd, 2024, and the green card was signed and received on March 7th. Just a little reminder on the short-term rental rules within the city is you're not allowed to rent less than 31 days or 1 calendar month. And that also includes advertising for rents of less than that. So regardless of whether you have a renter in there, if you're advertising for less than a month, it's still considered a violation. So this is kind of a blown-up picture of the Airbnb listing for this property on February 29th. You see here it has a minimum night stay of 7 nights. That's less than the monthly rental. And a couple other pictures. After the compliance date on 3/26, it still has a 7-night minimum night stay. And on April 16th, it still has a 7-night minimum night stay. And then on April 29th, it was complied. It has a minimum night stay of 30 nights, which we consider to be compliant. Technically, it's 31 days, but as you rent by night, we consider to be 30 nights to be a monthly stay. And for the business tax receipt, this is a screenshot of our Accel program. It shows that it's still pending on April 5th, which is after the compliance date. But they did pay on April 8th. So we have the receipt here of them paying. So at this point, everything has been complied, so we were seeking a declaration of violation.
Okay, so there's nothing to
Do
speak of.
you want her to come up? There'll be no need for you to come up unless you have something you want to say to the board.
And she does.
Will you state your name and address for the record, please?
Alexander Solomon. I'm here on behalf of 313 Leeward Island in Clearwater Beach, Florida, 33767.
And what's your relationship to the property?
I actually am the attorney. I'm not the client. I'm
Okay.
representing my parents who are my
Oh,
clients. So first and foremost, to begin, there was an issue with mailing in this situation. So I have a bunch of exhibits, if you guys would like me to show you them.
You really don't have to.
You're not being fined.
Yeah, we're
You're
not
not
being
being
So
fined.
there's no
Well,
fine at all?
Yeah.
Mr. Chair, I mean, they're entitled to make their
Okay, yeah,
presentation.
go
And
ahead.
the city is asking for a declaration of a violation, which would potentially trigger repeat violator status if future occurrences were happen. So it does sort of change their legal standing in this process. So I would ask that you just, whatever they want to present, go ahead and let them
Okay, go
do that. And if we have an objection or a rebuttal, we would ask for time to do that.
Okay.
Thank you, Mr. Simpson. As I was saying, there was a mailing issue in this situation, which I think goes directly to the heart of the issue, which is the alleged violations. So the first issue was that my clients only received the first violation, which was the business tax. And now I know Ms. Green had spoken with the other attorney who was on this case, and she had said that both violations were in the same envelope, but my clients did not see both violations. It was only one violation, and that violation was the business tax. Again, that was paid for on 4/8, but my client also reached out to Ms. Green at least a week or two prior saying, hey, I'm having issues uploading the payment. Is there anything that you can help me with? And they had an exchange between Ms. Green and my client. So that was the first thing. I do have a copy of the paid bill, but as you saw, it was already paid. The second violation was with regard to the Airbnb listing, and that violation was only found by my clients when we were sent the notice of a hearing, which was significantly later than the date of violation ended. So because of that, the first time my clients ever saw that they had to remove the listing from the Airbnb was when they got the notice of hearing for this hearing. So that was also an issue as well, because that was an entire month and a half after the violation had already passed. Both violations have already been remedied, and additionally, Ms. Green mentioned that somebody had signed the certified mail, but she didn't state who signed the certified mail. That was listed in this as well, if you would like to see a copy of it. May I approach?
Sure.
Yeah, there's
Yeah, you can put it on the screen.
Lit board to your right.
Oh, perfect, okay. So this is my exhibit 3, and this shows the violation affidavit and request for hearing, okay? On the very last page,
We can't read that fast.
You don't have to read it, because lucky for me, I spent hours the past few days reading it for
And
you.
there's no need to show it.
No, this is- thank you. So on here, it says that it's signed by what looks to be a Jeff. And there's nobody in the 361 Windward Passage family who is by the name of Jeff. So this was signed by somebody that we have no idea who it was signed by. And additionally, the address that was listed on here is 313 Leeward Passage. However, on here, it says legal description, Island Estates of Clearwater, Unit 1, Lot 35, but then up at the top it says Unit 1, Lot 325. So there could easily have been some mistake with where it was delivered to, because there is a 325 Leeward Island, which is only a few doors down, which I also have a copy of. Additionally, there's also a Lot 32 and a Lot 35, which I will also be showing you. So here, it says 325 Leeward Island, which is Lot 37, and Lot 35 is the property that my clients own. Now here is Lot 35 and Lot 32. So there could have easily been an address switch up, and as we all know how certified mail works, this is what the certified mail looks like, but there was no copy of what the address was when you guys sent the notice of hearing. So it could have easily said Lot 325, which could have been a switch up, which could have also led to some unknown person named Jeff signing off the certified mail saying that we received it when we in fact did not receive it. Now the way we ended up receiving it is it just somehow magically ended up in the 361 Windward Passage mailbox, which is the actual address that my clients live at. So we don't know how it came, when it came, and all that we know is that it showed up. And it could have easily showed up because my clients are well known in the area of Island Estates, so anybody who saw, whoever received this mail item could have easily seen that and then put it in the mailbox, or they could have easily looked it up. So those are the issues that I have with the violation, and my clients definitely do not want to be repeat violators. I do have copies of their license with their actual signatures, so you can see that the signatures don't match up to whoever it is that this piece of mail ended up going to.
I have a question for you.
Yes.
Do they understand that they actually had it on Airbnb for 7 days, 2 different times?
No, they weren't aware of that.
That it's their Airbnb listing. They should know
Yes.
what their Airbnb listings are.
They should, and you're absolutely
So
right.
they were in violation of it without knowing it.
Yes,
So
but also I
so
do
you
have
admit
an
the-
affidavit.
You admit there was a violation.
Yes, I do.
Okay.
But but the issue of it is the fact that they weren't given sufficient amount of time to remedy that before they end up having to pay whatever fines or become repeat violators. That's the issue that I have with me here today. I do have also an affidavit from the property manager as well. And he also says that he was unaware of the Clearwater requirement of a minimum of 30-day rental.
If he's a property manager, he should be very aware of it.
Which, you know what, I will gladly take that
I won't
up with
even
him.
ask who that is, because I don't want to know who it is.
Well, I was
but
about to
they-
show his name, but I guess I won't show his name
No,
for today.
that would be a huge problem on their part.
Mr. Chair, can I make a couple comments?
Councilor.
Just on the notice issues, the mailing and address and the legal description are two different things. An error in the legal description may create an issue for the city in the enforcement of a lien, because the legal description does become pertinent to the lien aspect. But that shouldn't have any impact on where it gets mailed, because the post office doesn't use legal descriptions, they use addresses. And in all the documents that I can see, we're using 313 Leeward Island as the mailing address. And so even if it was signed by some random person for some reason or whatever, it doesn't really seem to me like it's that relevant, because she's here. So if there was a notice issue, it seems that the city has remedied that by the fact that a notice of hearing was received. When that went out, that did attach the additional documentation that should have put them on notice if we made a mistake on the notice that was supposed to come before that. And so I think the fact that they're here, they're obviously aware that there was a problem. They don't appear to be admitting that, or denying that they were in violation either. Any kind of technicality with the notice having a mistake has been cured at this point in our view. And then, as you know, we're asking for a declaration of violation. You know, that's just whether or not it was being, the way the code's set up is if you advertise for a short-term rental, that creates a presumption that you are not using the property as a residential use. So the evidence was presented that has occurred. We're asking for the declaration. In some instances, renting out a property or advertising a short-term rental, the city views that as a irreparable violation. So a lot of times that notice of violation goes out, it gives the person an opportunity to correct. But with a short-term rental, there's really not much to correct there. Once that property's rented out, you know, the violation has occurred, and it's not, you know, if you stop renting it, you're just stopping future violations from occurring. So we often consider that to be an irreparable violation, and in fact, we've presented in front of this board in some cases and requests for fines to be entered as irreparable violations. And the reason I mention that is because the notice of violation would have more bearing on this case if it was a type of violation that could be cured. But we're talking about one that, you know, may have happened that may not have been curable, and therefore I think that the initial notice of violation becomes less relevant to the board, and to the extent that there was any error in it, I think it's been remedied by the fact that the notice of hearing contained the violation and they did receive that. So that's my response to the comments.
May I respond briefly? I would argue that it goes directly to the fact that my clients have a due process right to know exactly what it is that they have violated in order to be here to be heard, which is what every human being has a due process right. So my issue with that is, although you're saying that it goes a little bit less because of the fact that it's an irreparable violation, well, it was remedied, number one, and number two, it goes directly to the fact that the board gave a certain amount of days for them to be in compliance. If there was a mailing issue, then that goes directly to show that they didn't have exactly how much time they were supposed to have to remedy that issue and to be able to do it to be in compliance with the time that you guys requested them to be in compliance.
They do know now that
Yes, everything is squared away. It will stay at a 31-day minimum, and it will continue to be like that going forward.
Just to clarify, the board didn't issue that. That's issued by the city. The board is the body that hears the violation presented by the city. The board doesn't issue anything until after this hearing. So the board has no knowledge of what is done for violations. The board has no knowledge until we come here, so.
we just get a little paragraph of what it is.
And my head's about to explode with all this legal stuff.
So, I mean, just to, again, for the city, from our perspective, we recognize we're required by the statute to issue a notice of violation. That's the beginning of a case. That notice of violation goes out to the named person according to the tax assessor or the property appraiser. That's the address that we're required by law to send it to by certified mail. We're not required by any law or due process, constitutional requirement or anything to investigate the signature that comes back. If it comes back and it's not signed or not delivered, then there is case law, due process case law that says that now we know that it didn't get delivered and we have to take further steps. But the city is in no position to know that if somebody signed for something that they weren't the person that was supposed to sign for it. So if we follow the process, we mail out the notice of violation according to the property appraiser's records, then we assume that that was all fine until we're put on notice otherwise. The reason it's, I think, relevant if we mess that up is because we are required to give a person a reasonable opportunity to cure. That's a statutory requirement, not a due process one. But here is what I'm saying is it's less relevant because we're talking about a violation that really may not be curable because a short-term rental is not curable. And even if there was an issue with the notice of violation, that was later remedied when the notice of hearing went out. And that's what cured any due process issue, because here they are. Due process requires notice and an opportunity to be heard. And they were obviously notified of their opportunity to be heard because they're here. So our position is there's no due process issue. A violation clearly occurred. They don't even deny that. So we're just asking that the board affirm that a violation did occur, and then in the future, if it continues to be short-term rental, it'll be brought back as a repeat violator.
I have a question. Does the fact that a remedy on one or more violations occurred indicate or stipulate that there was a violation?
And I can tell you, the city's position is that there's nothing in the presentation that I've heard that they deny that a violation occurred. It sounds like there was some ignorance on the person that was in charge of managing the property, but ignorance is not a defense to the law. Courts have all said that people are expected to know the laws that apply to them and their property. So our position is that you've heard the evidence and there's a violation here.
Okay. Understood. My question was if a violation was remedied, then is that an indication that there was a violation? Okay.
Well, yes.
It's just that simple. Okay. Thank you.
All right, board, is there anything else?
Hope not.
We got everything covered?
Are we in agreement? Are we in agreement with this?
So,
Page 2.
you understand what
Yep.
we're saying. They were in violation, so we need to hold them accountable for that violation. And then if it happens again in the future, it will be a repeat offense, which you said that they understand what's going on now, so they won't make any more, there won't be any future violations, hopefully, right?
Yes.
If I get in trouble, I'm hiring you.
Well, thank you so much. I just passed the bar in September.
Well,
so-
congratulations. You did a
Thank you.
wonderful job. Thank you for your time coming.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine up to $500 for each day the violation continues to exist.
Need a second?
Second.
All in favor?
Aye.
All opposed?
Aye.
Motion carries. Thank you.
Thank you.
Have a good day.
Thanks, you too.
Our next case is 4.7, which is withdrawn. 4.8 is also, oh, no, I'm sorry.
4.6.
4.6, case
Yeah.
58-24. Find respondents Jin Bai Wang and Zing Tong at 200 Windward Island in violation of code for short-term rental, and issue an order with compliance deadline and fine if compliance is not met. Ms. Green, you have the floor.
Good afternoon, Board. Sarah Green, Code Compliance Supervisor for the City of Clearwater. This is case number 58-24 for 200 Windward Island. There is one violation for an illegal short-term rental and a development code violation against the zoning for the area. That's Code Section 1-104B and Code Section 3-919. Notice of violation was sent on February 20th, 2024, and the violation was posted on April 3rd, 2024, after the certified mail was returned unclaimed. This is a picture of the posting in the front yard. Very similar to the last case, this is an Airbnb listing, and we don't allow less than 31 days of one calendar month. What we're looking at here is on February 20th, there is currently no minimum night stay on that day, so you could rent it for 1 month. On March 18th, 2024, they technically complied. They had set it to a 30-night minimum. The next day, they switched it back to a 3-night minimum, so we obviously didn't comply with the case at that time.
They did it the very next day, they changed it?
Yes.
Oh, okay.
On April 16th, after the second compliance date, after we posted it, it was still a 2-night minimum night stay. And on May 5th, it was still a 2-night minimum night stay. May 13th, still a 2-night minimum, and this morning, still a 2-night minimum. So they have not changed. The posting is still currently short-term renting. Compliance can be met for the illegal short-term rental by ceasing to short-term rent the property and update all rental pages to reflect a monthly minimum night stay requirement, or by removing the rental listings altogether. Recommendation for case number 58-24 is requested compliance on or before June 22nd, 2024, or a fine of $150 per day for each day the violation continues to exist.
All right, board, do you have any questions for Ms. Green?
First violation? First violation.
Yes, for the short-term rental.
Right. And your mail was returned, right? As far as you know, they didn't receive the mail, the certified mail was
Yes,
returned?
no, they did not return the certified mail. It was returned unclaimed, so we then went and
Right.
posted the property. This picture of the
Right.
posting.
And it was posted what date? On 4/3?
April 8th.
April 8th.
April
Oh, no, April 3rd.
3rd.
April 3rd.
With a
Okay.
compliance date of April
All right. Have you heard anything from the owner?
I have. I've been emailing the owner a couple times, beginning of this case. It's kind of a little bit of a weird situation. Technically, they are renting to a renter, and the renter is subletting the Airbnb. It's a little bit of a weird situation, but ultimately, the property owner is responsible for what happens at their
Fines
property.
get passed down the line.
Wow, okay.
Any other questions for Ms. Green?
No.
All right, Ms. Green, thank you. Is there anyone here to speak on this property?
I'd like to say something, if I
Um,
could.
First, can we find out, is there
Yeah.
anybody?
Is there anyone here
here
that-
representing the property?
Representing the property? No.
Okay, then you can,
Are you, is this your property, ma'am? No, okay.
then you can come up.
So there's no one? I seen you started to get up, and I thought. Sir, please state your name and address for the record, please.
Good afternoon. My name is Joe Swiderick. I am at 206 Windward Island. I'm the house just north of 200 Windward Island.
Did you get that, Nicole?
Yes.
Okay.
I have a prepared statement if I may.
Sure, go ahead.
Thank you for allowing me this opportunity to speak. My wife and I purchased our property in August of 2019. Since that time, we've spent a lot of time, effort, and money in beautifying our property. We take great pride in our home and our community. We've done our very best to be neighborly and have met many wonderful folks within our neighborhood, most of which are here today. Okay? I can assure you the last thing that my wife and I ever planned to do when we bought our property was to testify at a board hearing against our neighbor. It's the last thing we wanted to do. Since we purchased our property, we had various encounters with Mr. J.B. Wang. Those encounters range from large rotted trees that hanging over to our property to broken down and decayed dock, which he was cited for, to loose hardware and electrical blowing onto our yard and into the canal. And it goes into trash not being taken down for weeks at a time. The piled up trash attracted large rats and crows. This is in Island Estates, rats and crows. I approached Mr. Wang as his neighbor, asking him to please fix the above issues. In a few of those instances, I even offered to pay half to have a lot of these things remedied, as I was trying my best to be neighborly. All of my conversations and offers were met with a smile and a promise to address the issues. I can tell you that none of those issues have ever been addressed. Today, I'm here to discuss Mr. Wang's illegal activity as it relates to renting out his property. City code, as Sarah had mentioned, allows for homeowners to rent their property for a minimum of 31 days. Since February 2024, Mr. Wang has both listed for and rented his property for less than 30 days. Many of those instances are 2 to 3 days. He further lists his property to sleep 19 people. There are bunk beds all over the place if you look at the Airbnb listing. When I approached Mr. Wang about this, I was met with the same response, that being a nice smile and a promise to fix the issue. We're here today because, once again, the issue is not fixed. Mr. Wang continues to this day to list the property out for less than the 30-day city mandate. As Ms. Green has mentioned, he is subletting the property, but I believe he's ultimately responsible. In early February 2024, the city contacted Mr. Wang, as Ms. Green has stated, as a courtesy to advise him that he was in violation of local rental requirements. Mr. Wang defied the city's emails and calls. The city later posted 2 notices on the property, as Ms. Green had mentioned. This was done in February and April of 2024. In both instances, and eyewitnesses, Mr. Wang or his renter simply took down the postings out of his yard and continued to list the property for the daily rates in less than 30 days. And Mr. Wang remains defiant to this day as we stand before you. My wife and I have been keeping records since February 2024 is my time out, if I may continue. And I know I went long. We've been keeping records of the dates and the cars that he has been renting. We have them here today if you'd like to see them. We're asking, given that we have no HOA in Island Estates to enforce rules, we're here to ask you today, as the code board, to rule against Mr. Wang to help us keep our neighbor beautiful. We're proud of our community. We're proud of the work the city does for our community. We're asking you to rule against Mr. Wang to stop this illegal activity to beautify our neighborhoods. Thank you for your time.
Thank you.
Can I ask a quick question of Inspector Green? You can just stay there, sir. Are you aware of the other issues that he brought up? Is anybody aware of the other issues?
Yes, Daniel brought the dock up last month.
Yeah, I recognize the picture. I'm like, wait a minute, we've seen that last
There's
month.
trash issues and all that other issues. Are you aware of any of those?
We've dealt with some things that have been fixed and go back to being things. So we have some transient issues.
Okay.
We're aware of them.
Thank you
Sorry
for-
you're having so much problem.
And I have
I
a,
didn't know that rats were allowed on Island Estates.
That's where they get the good trash.
Well, I'll tell you, part of it, he's got a beautiful mango tree in his yard.
There
I
you
love
go.
the mangoes.
Yep.
And he doesn't clean the mangoes, and the mangoes attract
I'm
rats.
gonna come
Oh,
over to the
yeah.
yard then.
It's a beautiful mango tree.
You have a question? Go
I
ahead.
do have a question for Inspector Green. How long has this been going on?
I received the complaint within mid-February, so I've known about it since then.
Mid-February, so it's basically 3 months this has been going on.
Yeah.
With
As far
virtually
as
no,
we've been aware.
no compliance or no correction.
Correct.
We will take care of it for you today, sir.
Yes, sir.
And no prejudice.
First time we had that.
So I have another question in
Have we
terms
ever
of-
gotten an applause? I don't think it's ever happened.
I'll take it.
Stuff thrown at us.
So typically, when we, just a general question that I don't have an answer to, and I'm just curious because this is somewhat of a little bit unusual to what we normally hear. When we enter a second motion, we usually give a date of 30 days. Is that a standard, or is that a must, or is there, do we?
No, and this is what we talked about before. You can, based on the facts and the
short.
circumstances, you
Yeah.
can decide shorter
Give them 5
period.
days? Yeah.
It's- I mean, a lot of times we'll go
Fine with me.
real short on a health and safety issue.
Yeah, okay,
Um,
thank
But
you.
the other ones are up to your discretion.
All right,
Can I get a motion?
yes.
Or if there's no more questions, can I get a motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? Motion carries.
I move to enter an order requiring the respondent to correct the violations on or before, what is today?
Today's the
The 22nd, the 29th? May 29th, 5 days?
The only thing, we're just checking how long it takes to get the order out.
So the orders,
That big Wednesday.
It's a holiday. Monday's a holiday.
Yeah. So what kind of time normally?
Yeah, see, it may be next Wednesday before it's signed.
I won't get
So
up there
you
to
may-
sign
10 days?
anything till-
10 days.
until
Probably
the-
10 days would be the minimum.
Do 10 days.
Give them
10
June
days.
2nd. I think it's.
Say June 5th,
June 2nd?
Or
June 2nd.
All right.
Sounds like Sunday.
I move to enter an order,
June 2nd, Sunday.
June 3rd then.
I move to enter an order requiring the respondent to correct the violations on or before June 3rd. If the respondent does not comply by that date, the board may order a fine of $150 per day, $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries.
Yeah, first violation can only be 150.
All right, next
Thank you
up
all.
on our docket.
Can I make just a quick comment?
No.
I want to thank this entire group for attending. That's quite a bit of community support. It's quite admirable.
Plus, you
Thank
had
you.
to sit through an enormous amount of legal stuff in the case beforehand, so, but now you're all lawyers.
Yeah. So
We don't get to see that many residents show up for hearings.
I have to earn my
We
money.
appreciate you coming and
Yes.
letting us know.
Yeah, thank you.
That speaks volumes.
All right, next case on our docket, 4.7 on our
Yeah, go,
agenda, and
wait a minute,
4.8.
wait a minute, Mr. Chair.
move on, can we make one statement
Wait, I just need, if it's
Yeah.
allowed, I just need it at
Come up to the microphone, please. Y'all has to go on our record, and she's got to be able to hear you.
First of all, thank you for the ruling. The question is, at the $150 a day, we consider a slap on the wrist. He can continue to rent that property. He's listing it currently for $600 a night.
Yeah.
So he can make a business decision to continue to list that property at $160 a night and rent it, for $600 a night, pay the $150, and he's still coming out ahead $450.
What happens is that if he doesn't come in compliance, they can come out and do a repeat violation. A repeat violation is $500 per day, up to $500 per day, and it's for every day that the inspector can establish that the violation exists.
Okay, so this is just a starting point.
Yes,
right?
yes, sir.
Okay.
You keep an
Start
eye on it
protocol.
and give him a call whenever it happens again.
Thank you.
Thank you.
Thank you.
Thank you.
Let us know. Thank you.
All right, our 4.7 on our agenda and 4.8 have been withdrawn. 4.9 is continued until June 26, 2024. 4.10 is also withdrawn. So that will be all of our new business for today. Now we will get to old business, which is accept the affidavits of compliance as listed for case number 5.1.1, 5.1.2, 5.1.3, 5.1.4, 5.1.5, 5.1.6, 5.1.7, and that is it. Can I get a motion?
I move
Wait a
to,
minute, don't you have one more, 1.23?
That, yes, that, I'm sorry, excuse me. No,
The very last one.
yeah, it would be case number 127-23. So, yes, thanks for bringing that to my attention, Mr. Schultz. The one that,
No, that's the
No,
next
no, no,
page.
no.
1.141.
yeah, that's a separate one to still do.
Okay.
5.3, 5.4, 5.5.
Yeah, but that's under 5.2. Let's get
Let's
all
do the
of
affidavits first.
5.1.
Oh,
Okay, sorry.
I move to
Okay.
accept the affidavits, accept the affidavits of compliance as listed.
Second?
all in favor?
Aye.
All opposed? Motion
Now
carries.
5.2.
Now, 5.2 on our agenda continued from February 28th, March 27th, and to April 24th, case number 127-23. Accept the affidavit of noncompliance for respondents Dorothy Fraley at 1754 Apache Trail for exterior surfaces and exterior storage. Inspector Dixon, you have the floor.
Good afternoon, Board. Inspector Greg Dixon, Code Compliance Inspector of the City of Clearwater. This is case 127-23, 1754 Apache Trail. Originally, when this case was brought before you, there were 3 violations at the property. There was an RV parked in between the house and the street, exterior surfaces, and outdoor storage. Today, I want you to consider accepting the affidavits of noncompliance for 2 of those violations for exterior surfaces and outdoor storage. Notice of violation was sent and posted back on 9/12 of 2023, and on November the 29th, the property was found in violation here at the board. The property owner had made attempts to correct the violations, and they did correct the RV. It was removed, but the outdoor storage and the home is still in need of repair. This is what the property looked like the day that it was initially violated. There's a lot of stuff stored in and around the house and behind the house. The house needs a paint job. There's a lot of rotten wood around the house. There's an RV and a fence and an ABV and everything that's been taken care of. So now this is the house. The bottom half of the house has gotten some attention in some of the shutters, but there's still rotten wood on the second floor. It needs paint. There's broken windows. Partially been painted on this side. This side of the house still has peeling paint. Oop. And there's a lot of random items being stored throughout the property. That's all I got for you.
Okay.
Is there anyone here to speak on 1754 Apache Trail? No?
All right. We ready? Yeah. I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if the fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Next on our agenda is 5.3 is withdrawn, 5.4 is also withdrawn, 5.5 on the agenda, case number 141-23, accept the affidavit of noncompliance for respondents QT Homes LLC, SRNK Gilbert P. Estates at 1233 Lakeview Road for landscape required. Inspector Teray?
Yes. Good afternoon, Board.
Hello. Good afternoon.
Name is Yusef Ture, Code Inspector for the City of Clearwater. I'm here in regards to 1233 Lakeview Road. This is case number 141-23. Number of violations of the property is 1, Code Section 3-1502, H2, ground cover, landscaping required. The notice of violation was sent out on 9/20/23. Compliance date was for 10/20/23. The certified mail was never acknowledged, was unclaimed. And they did an affidavit of posting on 10/31/2023. This is the property showing that landscaping is required. That was on, that was May 3rd, 2023. I went back on May 18, 2023. Nothing was done. Then it was September 26, 2023. Still nothing was done. Then I did an affidavit of postings on October 31st, 2023. It was the same date. And then a notice of hearing was posted on the property on May 10, 2024. Still nothing was done. And I went back yesterday, May 21st, 2024, and still nothing was done. And an affidavit of non-compliance was also was that? Oh, in February 2026, 2020. Sorry, February 26, 2024, an affidavit of non-compliance was filed.
Have you been in contact with any of the homeowner or anything?
I've been in contact with her a few times.
Yeah.
And she said that she couldn't do nothing with the property because it was in the former owner's name, and she was working with him to transfer it into her name. And I gave her ample time, but nothing was ever done.
Yeah.
And she did ask what she could do with the property. I did recommend that she could either pave it, she could have asphalt, or she could have it concrete, or she could also put landscaping there with mulch. But none of that was ever done.
All right. Board, do you have any questions for Yusef? No? All right. Can I get a motion?
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
Before I rule on that, was there anyone here to speak on this case? No? Okay. All in favor?
Aye.
All opposed? Motion passes. Thank you, sir. All right, now we are on to other board action, which will be 6 point, am I right? Or am I skipping one?
We skipped 5.5, didn't you?
Did I? No, that was this
That was
last
that
one.
one.
Yeah.
That was it, yeah.
Okay, our next on our agenda is going to be 6.3. We're going to go a little bit out of order. Case number 19-17, consider request by petitioners 819 Woodlawn Street, State Street Land Trust at 819 Woodlawn Street to reduce the fine, RE inoperative vehicle, grass parking, roof maintenance, and exterior storage, and if approved, issue an order that specifies a fine that includes administration costs and establishes a date payable on the lien, or the lien will revert to its original amount. Is there anyone here to speak on this case?
Yes.
Will you come forward and state your name and address for the record, please?
Yes. Good afternoon, board. My name is Pauline. I work for the trustee and I represent the trustee today. The address is 1619 Woodland Street, Clearwater.
Alrighty. So, and you're requesting a lien reduction on this property, yes?
Yes, please. So we got this violation in 2017, and at the time, the trustee hired a third-party management company. And unfortunately, the property management never informed the trustee of those violations. So we found out that the property is under a lien not long time ago. So this is why I decided to contact the city. The trustee would like the board to approve to pay the administrative cost of all those violations, if it's possible.
The administrative cost is $1,547.20.
I'm sorry, one more time?
$1,547.20.
Get three. Get three.
Is this one of these, the city worked this out? Is this
Yeah, does the city have a
We
position?
haven't previously worked out any agreement to reduce this one. I believe that we do have information about the current situation out on the property, if the board would like to hear about that.
Rebecca, Code Compliance Manager. Our inspector did go out to the property, similar to how all reduction requests go. An inspector will inspect the property on the violations. And based on those photos, it does appear that there are still violations on the property, except for the grass parking, which is no longer an issue, but there was an ABV on the property, as well as the roof was still dirty, and there was still outdoor storage and debris found at the property.
So it's not in compliance.
What did,
Thanks for letting us know, yeah.
I have a question. That we addressed the subject earlier about addressing lien reductions when basically the violations weren't corrected or complete.
Yeah.
You may have to refresh my memory.
You
but-
can continue this and say that you want the violations corrected before you'll consider
Yes.
the fine reduction.
Yeah, that makes sense to me.
Yeah. You understand that we're gonna continue this until, you know, you can get the property into compliance and
Can we get the pictures if you don't mind? Because I have not received those before the meeting.
They can get with the
If I
inspector.
get the picture, that would be great.
Yeah, we can send you those photos, and we can have you work with the inspector in that area to go over exactly what needs to be done.
That would be great, yeah.
We can set it for the next meeting if we believe everything, at least to give us a status update.
I like that, yeah.
So if that's okay, we'll put it on next meeting.
Do we need to make a motion to that, or just leave it?
A motion would be appropriate. A motion to put it on next meeting to be considered by the board. If it's just the status and that's all you'll consider, and you'll continue it if you want, or whatever action you want to take.
Okay.
I make a motion to continue case 19-17 until our next meeting of.
Next
Nicole?
board meeting.
To our next board meeting in June?
June 26th.
June 22nd?
26th.
26th.
Yes. Yes.
Second?
Oh, second, yes.
all in favor?
Aye.
All opposed? All right, motion carried. Just try to start getting into
Yes.
compliance, and we'll re-see this next month and see where you're at as far
We'll
as
do it
that.
tomorrow
And then
morning.
we'll address the lien reduction either then, or we'll see what the status is.
Yes, I will be there. Thank you very much.
Thank you,
so much.
Colleen.
Thank you.
Okay, now let's go back to 6.2, case number 49-11, consider request by petitioner Kobe Elaine at 1317 Byron Drive to reduce the fine RE exterior surfaces, and if approved, issue an order that specifies a fine that includes administrative costs and establishes a date payable, or the lien will revert to its original amount.
Or did we skip over 6.1?
That's supposed to be
Yeah,
last.
that's going to be last.
Oh, okay, you told me that earlier, I'm sorry.
That's all right, that's all right. Who's on this case?
Doesn't say.
Doesn't? All right, is there anyone here to speak on this 1317 Byron Drive? Good afternoon, sir. If you'll state your name when you get to the podium and your address for the record, please.
My name's Alan Colby. It's 1317 Byron Drive. I'm here to petition the board for a lien reduction. Reason being is that the liens were being assessed in 2011, and we did not own the property until 2017. So at the time, we were unable or unaware that anything was going on, and then we did get them remedied. I believe it was closed in 2018.
Your title company didn't find liens
No,
on it?
what happened was the purchase, it wasn't an individual sale, it was a company, where we purchased the entire company, and it was just part of a bulk sale. It was part of 1,100 homes, so it was one of 1,100 homes.
Oh, okay. Wow. That's a big purchase.
That's just in Tampa Bay.
It's a big lien.
So.
The
Now-
administrative costs are $1,135.20.
Do we know what the violations on this property were?
And are they in compliance?
And are you in compliance today? Before we,
Exterior surfaces was the violation that was brought before the board back in 2011.
$100 per day, and the total amount is $250,000. $250,100.
don't forget that 100. Is the property in compliance today?
Yes, so I was told by the code enforcement, the Coast Guard, that it was compliant back in 2018.
Compliance today. Board, do you have any questions for Mr. Allen, or for Mr. Colvin?
So what number do you want to do?
I'm all for just the administration cost.
Yep, absolutely.
You got it.
$250,000.
It was-
A lot of money.
It was bought, they bought it.
I know.
I'd be compelled to do it too,
In this case.
We both want to go with administration.
Let's go with it.
Yeah.
Yeah, I'm with that.
with that?
I'm
Yeah,
looking for the motion.
Yeah, we're looking for the motion.
All right, can I have a motion, please?
Yes.
We're looking for it.
I move to order, I move to enter an order reducing the amount of the lien to administrative costs of $1,135.20 payable within 30 days, or the lien will revert to its original amount,
22 cents.
22 cents. Thank you.
22
Second,
cents.
I'll second that.
All in favor?
Aye.
All opposed? All right, motion passes. Thank you, Mr.
Good
Colvin.
luck, Mr. Colvin.
Thank you.
All right, now, our next
6-1.
one
That was
is
a good one.
6.4 on our agenda, case number 02-21, 93-21, and 135-21. Consider the request by petitioner Christine Dorsalis at 214 South Highland Avenue to reduce the fine for short-term rental, grass parking, delinquent business tax receipt, and if approved, issue an order that specifies a fine that includes administrative costs and establish a date payable on the lien, or the lien will revert to its original amount. Is there anyone here to speak on that case?
There she is.
All right, here we go.
We've got desired lien reduction 0.
Yeah, they want 0, they want big.
Hi, will you state your name and address for the record, please?
Yes, my name is Nikki Yang Victorino, and the address is 214. It's actually Highland Avenue, it's not South, but South Highland Avenue.
And how are you related to the property?
I am Miss Christine's realtor.
Okay.
She has the house right now on the market for
And you
sale.
have permission to speak on this?
Yes, I do. She sent me, her statement.
Yep.
Okay, so,
she's requesting the reduction of the lien and the fines, and this is what she told me. She said okay, so the property she had squatters on the property, right? So the squatters who starting there, okay, she was a traveling nurse, and she was working as a traveling nurse during COVID. I wasn't getting this correction violation post notes. The one for business, I think there's several violations. The one for business, she wasn't doing any business then. I had no knowledge that the license needed renew. Since the squatters took over for over 2 years consecutively, I had no way on doing any business. Otherwise, the Airbnb that she was there, I couldn't do that because I was not only there, but also was squatted. So I guess she wasn't doing any Airbnb
The squatters were.
because the squatters were, right? So the violation were the first group of squatters. They had cars in the back that nobody could remove because they had trespassing signs, locked up things, had firearms warnings. They were holding the house in a very hostile way. I got them out and fixed the house, but went away to work as a travel nurse again, and other squatters took over. I forced myself to move into the unit. They didn't squat to prevent more squatters take over, and I tried being friendly with them, letting them in and out of my house to do laundry, hoping they would leave, as they keep promising me to help me and leave. Instead, I got raped and beaten by their friends, which I believe was an attempt to make me scared and leave my house. They even asked me to put their name on my house deed. They scammed the previous owner by running utilities on their name and my name, leaving huge debts behind. Police refused to help me, saying all I can do is evict them. No arrest was made. They stole my big appliances. All those things are reasons why I'm uncomfortable to even revisit the house. I left for good in disgust. Now I just need to restore my nervous system. I'm not back to travel. She's not back to travel nursing since that rape and getting physically assaulted. I'm still recovering from this whole trauma. She's not in Clearwater. She's not coming back.
I have some questions.
What's the status of the house now? Is it?
Well, all the violation has been corrected. All the vehicle has been removed. The RV that was parked outside in the grass, I have pictures being removed as well. We called a tow truck.
Squatter's gone?
The squatter's gone. We boarded up the house.
That's good.
Finally, I mean, we drive by there every day. Our office is like right next to it. So I drive by there every day, making sure there's no one there. There's no electricity, no water, because we don't want the squatters to move back in. The windows are broken because that's how they get in. So right now, we're just trying to sell the property and reduce the lien so she can move on.
And the current lien amount is $2,500?
No, the current lien amount is $18,300. The administrative costs in this one is $2,989.60.
Rebecca Mulder, Code Manager. I also wanted to provide an update on this property from our inspection, if I could.
Yes.
So the inspector went out to the property, and we also checked our records. This property is not currently being rented short-term, and they do have, they did at that time obtain their BTR. They don't have one now because they're not renting, and there is no grass parking. However, there is an active case for debris and overgrowth at the property currently. It hasn't come before you, but it also hasn't been closed out and rectified either.
All right.
And so on that, just to make a comment on that, we do anticipate, if it's not remedied, we do anticipate bringing that before the board, so we don't necessarily want to get into all the details of it until that's properly noticed and brought in front of the board. It's our position that you still have it's your lien, so you can reduce it or not, or whatever you want to do
But
with it.
either way, that would be a separate case.
This would be a separate case that would come later, but as we've talked about before, whenever you're considering fines, whether imposing them or later reducing them, the existence of violations is something that's relevant for you to consider, so that's why we bring it to your attention.
Thank you.
From my understanding, that the violation that exists now is not an uncured violation from previous, it's a new one. So it stands, we could view it to stand outside of what we're addressing here.
It does, yeah, it does.
It's also, there's no one's living there, so it's, grass is gonna get, if she doesn't wanna come, if the owner doesn't wanna come
Yeah.
back because of previous stuff, that had happened, so.
I guess the question is, being that there's an active case, granted that it's not part of the original violations, does that mean we continue it till the violations are cleared and then address it, or do we deal with this now and treat it, the other one as a separate case? That's my question.
I would say deal with this one now, and
Yeah,
we'll deal with
collect-
that one when it comes before us.
Collect the fees now, and
That's what I would.
Like I said, we defer to the board on how you want to handle that, and if it's not corrected, it will be brought before you. So it's our position that it's in violation right now. Legally speaking, it's not technically in violation until the board determines it to be that, and an order is entered, so, but.
And that was for, Ms. Mulder, that was for what, high grass, or was that what it was? It's in violation now?
Debris and overgrowth, yes, so the grass as well as a bit of debris in the yard.
Okay.
Maybe from the squatters.
Well, you heard that, so you might
Right,
want to
that-
take, you might want to take care of the grass and debris in the yard so you don't get stuck on another one,
Right.
But-
We didn't even get that one yet. The last one that she got was the RV parked on the grass, so that one was taken care of, but I guess this one is the
You
new
might
one
want
that just
to,
came.
after this is cases,
Yeah.
you might want to
The
get with Ms.
inspector for
Mulder.
that area
say
is
we get rid of
in
this
here
one.
right now.
Mr.
So
Saltzman,
you
what
can
was
get with
the-
him before you
The
go.
lien amount again.
$18,300.
18,300, thank you.
Oh, I'm sorry.
The administrative cost on this is $29.89.
Yeah, I got that one. I just didn't have the
18,300.
original. Okay.
So, I'm inclined to,
Administrative costs.
Yeah.
Yeah, let's do that.
All right. I move to enter an order reducing the amount of the lien to administrative costs of $2,989.60 payable within 30 days?
Yeah.
Or the lien will revert to its original amount.
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you.
Thank you very much.
Thank you.
All right, next case on our docket is going to be case number 139-17, request to stop lien accrual for Torrin McCray at 1326 Fairmont Street in violation of code for lot cleaning. Inspector Dixon?
Afternoon, Inspector Dixon, Code Compliance Inspector, City of Clearwater. This was for case 139-17, 1326 Fairmont Street. When this property was brought before the board in 2017, it was for two violations, accumulation of trash and debris and outdoor storage. The property was found in violation here on 9/27/2017. The current total lien amount is $710,000. I'm asking that we request that the lien for the lot clearing be stopped so that I can post the property for lot clearing, eventually get an abatement order to clean up the property.
I'm sorry, I didn't hear that last part.
I'm asking that we stop the lien for the lot clearing so that I can open a new case and come before you and get an abatement order so that I can clean up the property. It just needs mowed. There's a lot of appliances, trash strewn throughout the property.
Is there anyone living there?
Yep.
Is there? Do they know that these liens have been accruing, yeah? No?
Yeah. We sent out a list like a year ago of everybody that had big liens. So they're aware. So the liens aren't working, so.
Clean it up.
Clean it up. Okay, board, do you have any questions for Inspector Dixon?
Sounds like a strategy.
This is certainly one of those cases where they're thumbing their nose at the city.
You think?
Yeah, but he wants to get it stopped, so
Yeah, no,
get
I
it stopped so
understand.
he can go
I
another
agree.
direction.
The property's homestead, so we can't foreclose on it.
I understand,
So-
yeah.
It's an example of what we talked about.
Yeah, that's what I'm saying.
Exactly. Does someone want to make a motion?
I make a motion to request to stop the lien accrual for Torrin McCray at 1326 Fairmont Street in violation for code for lot clearing.
Second.
All in favor? Aye. All opposed? All right, motion
carries.
For the abatements that we're about to start, if we could hear item 7.4 first.
First? Okay. All right. Thank you, Inspector Dixon. Okay, now on to nuisance abatement lien filings.
Stay around.
Oh, yeah, you're on this one too. We're gonna go with 7.4 on our agenda, case number 78-21. Accept the nuisance abatement lien for respondents Alpine Oaks Apartments, Inc. at 2007 Alpine Road, number 1, for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon, you have the floor.
Good afternoon, Inspector Dixon, Co-Compliance Director for the City of Clearwater. This is case 78-24 for 2007 Alpine Road. There's one violation at the property for accumulation of trash and debris. Notice violation was posted on 5/9 with a compliance date of 5/19, and the certified mail was signed for or received back in the office on 5/20. This is a community that looks like one large apartment complex, but there's several parcels. Most of it's owned by one owner, but there are a couple of parcels that are owned by different owners, and this one is 2001, 2007 Alpine. It's kind of back in the corner, but it looks like there's some move-outs and a bunch of furniture has been placed at the property. And it's still there. The larger property owner is Lennox Apartments, and I've been in contact with the property manager, and they have their own junk removal for when people move out and leave stuff out for, and the rest of the property is immaculate. It's just this one corner, so it's pretty safe to say it came from that corner. Compliance can be met for lot clearing by clearing all discarded furniture and debris from the property. And my recommendation is request compliance 5 days after the board renders its order.
Any questions, board?
Is there anyone here to speak on this?
Is there anyone here to speak on this, what is it, 2007 Alpine Road, lot number 1?
He's the property manager that I spoke of, but if you don't have any questions for him, then that's it.
I don't, do you have any questions for him? For the property manager? All right, can we get a motion?
I move to enter a fine ordering the respondent in violation of the code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry into the property to abate and maintain the nuisance, and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. All opposed? All right, motion carries. All right, now back to 7.1 on our agenda, case number 64-24. Accept the nuisance abatement lien for respondents Nezer Enterprises LLC at 1403 Gulf to Bay Boulevard for inoperative vehicle, and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Stevens?
You start with the previous people.
John's not here.
Can we pass, Mr. Chair?
What?
I believe our inspector for this case is out in the hallway. Can we
yeah,
pass
yeah.
to the next one?
Okay,
Yeah,
well,
he just has this one.
is that who? 7-2? Okay, we will.
Prince, you're ready.
Well, can you have some identification on you, please?
Hold on a second.
Okay.
Hold on a second.
Wait a minute, here
Hold
comes
on.
John here.
No.
John, you're
Well,
up.
all right.
You're up, Mr. Stevens.
Here we go.
There's no audience left.
Juggling inspectors.
Bear with me 1 second, sorry about that, board.
It's all right.
Go out and get nicotine.
There goes, huh, John? You go out in the hallway and you're up.
Happens again, you buy us lunch.
All of us.
Checks in the mail. All right, good afternoon, board. John Stevens, City of Clearwater, Code Compliance Inspector. This is case number 64-24, reference 1403 Gulf to Bay Boulevard. This is a nuisance abatement case. We have one violation here for Code Section 3-1503B6, which is storage of an inoperable vehicle on private property. Notice of violation, actually, well, the initial violation was on February 29th of this year, and I noticed inconsistency with the tag, so I had to do a little bit of extra research on it. So it actually got posted in mail on March 1st. and with a compliance date of March 22nd. And we received the green card or certified mail back to us, signed for on March 22nd as well. And actually, let me go back one slide real quick if I can, excuse me. There you can see my posting there on the window of the vehicle on that date. And then this was the condition of the vehicle on the 29th there. You can see it's got a flat tire, and then the tag, it shows it expired in March of 24. But you'll happen to notice if you look at the yellow sticker on it, that the numbers on the sticker don't match the tag, which in Florida, those normally line up. So I was suspicious that this was actually probably a fraudulent tag or something of that nature. This was actually on the compliance date. You can see the tire is still flat, and that the sticker is now updated to 325. I was able to find a phone number for the property owner and get a hold of them and talk to them, and they claimed that the tag was valid and that sticker was correct. So when I ran it through basically the Florida DMV system, I was able to find out that the tag itself used to be on that vehicle, but it expired in March of 21, and a new tag was issued which matches the other sticker, the Y824IK, and it's valid, but where is the tag? Because the numbers, he doesn't match. So I explained to him that the right tag has to be on the vehicle with the right sticker, and the tire has to be fixed. He said he would get it taken care of, and on April 25th, it is still the same. And today, it is still the same. So compliance can be met for the storage of an inoperable vehicle by obtaining and displaying a legal license plate on the vehicle, repairing the flat tire, and maintaining condition for the vehicle so it's both mechanically and legally able to operate on the road. And we are just requesting compliance 5 days after the board renders its order.
All right, board, do you have any questions? Inspector Stevens?
No, it's good.
Can I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. All opposed? Motion carries.
Thank you, board.
Thank you, John.
7.2 on our agenda, case 67-24, accept the nuisance abatement lien for respondents Andrea Bashir and Esther McHale at 1033 Fairwood Avenue for lot clearing, and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Still, you have the floor.
Good afternoon, board. And, whoops, it's loading. There we go. All right. Today I present to you 1033 Fairwood Avenue. It's going to be a nuisance abatement. My name is Mark Anthony Still, and I'm a co-inspector for the city of Clearwater. Numbers of violations, we have two. One's going to be 3-1503B7 and B5A, which is overgrowth, accumulation of weeds, and accumulation of debris, trash, and junk. Notice of violation was sent on April 3rd, 2024. Affidavit posting also the same date, April 3rd, 2024. Compliance date was May 3rd, 2024. And the sole contact with a person identified as the owner was on May 8th, 2024. The original posting is on the left, which is the 3rd, and then I had to repost on the 7th because I had the wrong date for the board. I had the 26th instead of the 27th, so a little admin here. That is a picture through the open gate where we have debris on the side towards the rear of the backyard. There's a lot of debris not associated with regular yard furniture. as of patio furniture, for example, it's just debris and scrap. Then we have the utilities are disconnected, as well as Clearwater solid waste is not picking up the trash there. So if the trash cans there, mailbox outside, certain debris on the driveway, as well as building materials and random recreational vehicles. Then in front of the structure, principal structure, we have furthermore debris. Then overgrowth in front of the building in excess of 12 inches. And that is the view from the street side. We have general overgrowth and accumulation of debris on the property. And the neighbor granted me access to his property, which sits at an elevation adjacent to the property at 1033. And where you can see the backyard is great accumulation of debris. It's a little zoom in. And as you can see, it's scrap. It's not associated with any garden furniture. And you can also see it from Google Earth, because I'll try to get a better angle. When I made the contact on May 8th with the owner, I told him I could meet him the next day. I waited for 45 minutes. He didn't show up. And there was no further communications with the owner. And that is a picture from today, this morning, still with those violations. The utilities have been disconnected effectively since June 2023. The last contact with the owner with utilities was in April of 2023. Compliance can be met for lot clearing by removing all plant materials, overgrowth, and dead vegetation from property. Furthermore, all removal, debris, scrap, building materials, and junk in the front yard and behind the principal structure. And then once, I guess, solid waste is contacted again, maintain proper garbage disposal methods for the trash cans near the curb, so they can dispose, because the trash cans are all full in front of the structure. And requested compliance on before 5 days from the date the board renders its order.
So, Mr. Steele, the house is abandoned?
As of right now, the owner stated, or the person who called stated that he wants to fix it up and rent it out, but it has been vacant since I've been working here.
Okay.
And I haven't seen it in a different state as far as the debris. And,
I have a question. I noticed the violation is for the accumulated trash and overgrowth and accumulation of weeds and all of that. I also know that, based on our experience here, that when the utilities are off, it's considered abandoned dwelling. And so I'm curious as to why it's simply, the violation is simply for the accumulation of debris and not for an abandoned dwelling.
Well, I have another case on the structure, and it addresses the status of the building, and which leads to abandoned case for the structure. Okay. But I gave a greater timeline because it was easier to fix the accumulation of debris first in the overgrowth and try to make contact or positive rapport with the owner. But I already have a case of a CDC case as well for the structure and the condition of the principal structure. And since there's no communication with the owner, I'm going to expedite that as well. Okay. So we can handle that.
We're also asking for abatement authority for this, so we don't have the ability to abate an abandoned building, but we do have the ability to cut the grass and take the trash out, so that's why they're separated.
That makes sense.
Any other questions?
That's a good answer.
Inspector Still? No? Can I get a motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? Motion carries.
Thank you.
Thank you, Mr. Still.
Next is 7.5 on our agenda, case 79-24, accept the nuisance abatement lien for respondents Robert E. Cox at 1204 Claire Drive for inoperative vehicle and issue an order with compliance deadline, authorize the city to mitigate the violation if compliance is not met. Inspector Dixon.
Get the last three.
Afternoon, Board. Inspector Dixon, Code Compliance Inspector for the City of Clearwater. This is case 79-24 for 1204 Claire Drive. One violation at this property for an inoperable vehicle. The notice of violation is posted mailed on 5/3 with a compliance date 10 days later. The home's vacant, so the mail is coming back. There's nobody there to accept it. This is the vehicle in question. It's got flat tires. Tag expired in 2015.
Wow.
That's my posting.
It's only 9 years ago.
And this is this week. There's no change with the vehicle. Compliance will be met by removing the vehicle from the property, display a current registration sticker, inflate the tires, and make the vehicle roadworthy. I'm requesting compliance 5 days after the board renders its order.
All right. Board, do you have any questions?
You're doing well on these long ones.
Yeah.
You have any questions, anyone? Can I get a motion?
I'm getting dry.
Yes, Mr. Chairman. I move to enter an order finding the respondent in violation of code, requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate, maintain the nuisance, and charge the respondent with a reasonable cost, which will become a lien on the property. Costs, fines, and fees remain unpaid 3 months after such a lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Need a second? All in favor?
Aye.
All opposed? Motion carries. All right, 7.6 on our agenda, case number 80-24, accept the nuisance abatement lien for respondents Jesse Williams at 1320 Springdale Street for inoperative vehicle and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon, you have the floor.
Case 80-24, 1320 Springdale Street. There's one violation for an inoperable vehicle. Vehicle is posted on 5/3 with compliance date of 5/13. This home is also vacant and the mail will be returned unclaimed. It's an older vehicle. It's up on blocks, got flat tires, no tag,
No shit. No.
Yeah, it's a class.
and it's currently in the same condition. The gentleman's older. He's in a nursing home. The family don't want to take any responsibility for it, so it's going to have to be towed. Compliance will be met by remove the vehicle from the property or store the vehicle in the garage, and I'm requesting compliance 5 days after the board renders its order.
All right, is there any questions? Other than,
Where the car
what's
is.
the name of the guy so I can go buy the car?
Yeah,
Daniel said he's got first dibs.
that's the last thing.
Yeah?
No
Mr.
questions?
Mr. Schultz might want to take a
No,
shot.
sir, no, sir, I'm out of
Okay.
the car buying business.
All
No,
right,
no, I'm talking about reading the
Oh, no, I know.
nuisance abatement.
You do such
Can
a
I get a
good job.
motion?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry into the property to abate and maintain the nuisance and charge the respondent with the reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. All opposed? Motion carries. And the last one for today is 7.7 on our agenda, case 81-24, accept the nuisance abatement lien for respondents P&B Florida Land Trust 2000 at 1090 Apache Trail for lot clearing and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon, you have the floor.
Case 81-24 for 1090 Apache Trail. There's one violation for accumulation of trash and debris. It's actually some homeless camps and activity on a vacant parcel that sits between Apache Trail and the Pinellas Trail just south of Stevenson's Creek. Notice of violation was posted on 5/3 with a compliance date of 5/13. This doesn't really show you a whole lot. It's a bunch of Brazilian pepper trees on a vacant lot, but creates a hiding spot. There's a homeless camp. The neighbors that behind this have called and called the police, and the police contacted us. So there's this one homeless camp, and then this week that homeless camp is still there, but another one has popped up adjacent to it. So compliance can be met for removing all transient camps and debris from the entire property. I'm requesting compliance 5 days after the board renders its order.
Board, do you have any questions?
Unfortunately,
I'll
the
make a
pepper trees are still there too.
Make your motion.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry into the property to abate and maintain the nuisance, and charge the respondent with a reasonable cause which will become a lien of the property. If cause fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries, and if that is all for today, board, we are adjourned.
Right.